Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio super lawyers. More answers, more help, more law on Fox 19.
Welcome back. It is time now for More Law Connection, where attorney Dan Moore is taking viewer questions via email. Dan, go ahead.
Thanks, Deb. Good morning, everybody. Our first email today is from Bill. His question is, do I have to take a roadside sobriety test? Well, the roadside sobriety test is, for those of you who haven't had the pleasure of performing it, these are the tests where the officer asks you to follow his pin, he asks you to walk in a straight line, he asks you to raise your leg. Those are the roadside sobriety tests. In Kentucky and Ohio, you don't have to take those tests. There's no penalty for not taking those tests. Most DUI attorneys are going to tell you, don't take the test, because what you're going to do is give the officer evidence to use later on at a trial against you. So in addition to that advice, my advice is don't drink and drive, don't get in that situation, you won't have to worry about it. Deb, back to you.
Dan, you have the greatest advice. Let's see, we have another caller we want to get to right away. Lori in Blue Ash. Lori, I understand, if I'm correct, you and your boyfriend never been married and have a couple kids, and you had a question about how you'd handle that if you split up?
Yes, yeah, I just wanted to know, if we were to split up, how would we decide custody?
If you never marry, then you will decide custody in juvenile court instead of in domestic relations court in Ohio. Juvenile court is for families where there are children but the parents have never been married. So you would go through a juvenile court proceeding for custody and parenting time and child support. If you get married, then you would be in domestic relations court.
Which one's more difficult?
There really isn't. I mean, when you do it in domestic relations court, it's all part of the process of terminating the marriage. So you're also dividing property and dealing with spousal support issues and other tax issues. If you're dealing with just the children in juvenile court, then it is just the custody issues.
Right.
So it's the parenting time, but the concepts are the same.
Okay, great. Thank you.
Barb, do you find normally in basically the criteria that's used to make the decision with respect to custody and visitation and things like that, it's pretty much the same in juvenile, or is it different?
It's identical. It's the same statute.
Okay.
Okay.
Just a different court.
All right. We have another caller now. We're going to go to Bobby. Bobby, go ahead.
Yes, my question is, I have had permanent custody of my niece and nephew since March of 2011. How long, and does the biological parents, have to be in court before we can start adoption proceedings?
How long do the natural parents have to be in court?
How long do we have to wait before we can start the adoption proceedings? And what if they can't locate the biological parents?
You're asking a question about probate court, and that's not an area where I practice. So I'm going to give you my best understanding, which is that I think if the biological parents have been absent without contact with the children for a year or more, that they don't have to be notified of an adoption proceeding. But that's a probate court proceeding.
Well, one of the things also, Barb, is it not correct that if these people don't actually have legal custody, that's something they may work for immediately, even though it's not an adoption, because basically these folks are going to have to, if the kid needs medical treatment or something like that, they've got to be able to get permission.
I thought she said she was the guardian, but if I'm wrong, then Don, you'd be absolutely right that if you get your legal rights first with respect to those children, but if you are already guardian, then...
Right. If she isn't, she should be,
yeah.
and so on.
Right.
Great.
Okay, Bobby, best of luck to you taking care of those kids. We want to go back to Dan Moore with another email question in the Moore Law Connection. Dan?
All right, thanks. Lauren writes, my dog bit my neighbor's dog. Do I have to pay the vet bill? Same thing happened to my sister. Large dog attacks her small dog, causes lots of damage, almost kills her dog. The dog has to go to the hospital and incurs all kinds of vet bill. The answer in Ohio, Kentucky, again, is the same. Both states are strict liability states. That means that if you're the owner of a dog that bites another dog, another person, or does harm to other property, you're responsible regardless of whether you're at fault. So my advice to you, look at your house, look at the enclosure that you keep your dog in, make sure that that dog can't get out or do harm to anyone else easily, because you don't want that dog to cause you trouble. You want to enjoy that dog, of course. If you have questions, go to the Fox 19 website, click on the More Law button at the top of the page, fill out the Send Us Your Questions form and click Submit. We might even use your question on the show, but we'll do our best to answer it. And if you stay tuned with us, you'll see some more calls that we're going to answer and hopefully help some people out. Thanks a lot.
Thank you, Dan. And now I think, Don, you wanted to mention something about what Dan was saying.
I think he loved that question. You know, he just got a new puppy.
He did.
Yeah, so if it comes a dog question, I think he's going to be all over it.
All right, well, so send us all of your dog questions. I don't think she's a dog question, but we have Jamie on the line. Jamie, you had a question for us?
Yes, ma'am. I was wondering how it is a person that has been indicted on a rape charge concerning a minor, but plea bargained that charge down to an assault and has been convicted of numerous other charges involving minors. I was wondering how it is that that person was now able to get custody of a child and maintain custody so far when that particular child has also accused him of molesting her.
That's a good question, and I would need to know more about the specifics of that. We certainly have a provision in our factors when we look at custody as to whether a person who's seeking custody has been a perpetrator of abuse. So if that's a situation, I would be very, very surprised to have that person receive custody. But it could be perhaps it's a lesser evil of two choices, so to speak, that neither parent is particularly suited. But I would have to know more about the situation.
The custody business is a really fact-driven.
It is.
There's law, right?
Yes, but it's very fact-driven. There are a lot of factors the court looks at, and one of them is whether there's been abuse and who's perpetrated it.
And the paramount thing, best interest of the child.
Best
right?
interest of the child.
And there can't ever, or very rarely, be a situation where somebody says, "Oh, I'm just." It's always kind of a he said, she said sort of scenario.
More often than not, but there are times, certainly we have witnesses other than the parties who can verify what one person said and what one didn't, or sometimes there are documents, exhibits that will come into trial, just like any other trial.
All right, okay, thank you. We will be back with more law in just a minute. Stay right there.